Commissioners. For the record, Attorney William Smith for the state. This next matter is in the matter of a complaint by Kirk Carr of Clinton. It's file number 2014-053. For the Commissioner's information, I do see that Mr. Carr here is here today in attendance, and that this complaint was brought by Mr. Carr based on an allegation that a citizen's guide to the 2014-2015 public schools budget was produced at public cost while a referendum was pending, that it obligated, and therefore there was a violation of 9-369B in that the Clinton Public Schools failed to obtain approval by the legislative body and municipal attorney in getting this information published as a guide and then disseminated to the citizens in Clinton. The Commission used a three-prong analysis in Section 9-369B to analyze communications that have allegedly violated the prohibition. One, whether the communication advocates. Two is whether it was made at public cost. And three, whether it was made while a referendum was pending. This findings and conclusions does map out how the Commission has treated these matters in the past to determine how and when a referendum is legally pending. And in this instance, the allegation is not supported by the facts after investigation because the analysis doesn't support the conclusion that the referendum was pending while the communications were disseminated, and therefore it does not trigger the application of General Statutes 9-369B because the information in the Clinton annual budget guide occurred or was disseminated around May 1st or May 2nd, 2014, and this was prior to the May 7th Clinton annual budget meeting, which then triggered a notice of public referendum on May 8th, 2014. So by the time the referendum was pending at about May 8th, 2014, these guides had already been distributed, and therefore the prohibitions and requirements of 9-369B wouldn't apply to materials that were disseminated prior to a pending referendum. I ask, therefore, that this complaint be dismissed.
So in other words, it's immaterial whether it's advocacy or not. It doesn't get the...
Correct. We don't reach the analysis of whether publicly funded materials advocated or not as to 9-369B unless the referendum was pending. Because the prohibition in the language of the statute says you can't do this, the materials can't advocate a yes or no vote while a referendum is pending or with regard to a referendum. At this point, the referendum wasn't pending, and that's the standard that this Commission uses to determine whether 9-369B applies.
Does Mr. Carr want to address the Commission?
I don't know. He hasn't spoken to me this morning. I have no objections.
I'd be happy to.
Take it to SEEC.
Okay. The Board of Finance passed this budget on, do you have the date? Give me the date that they passed it. I think I gave it to you in a memo. I wasn't aware I was going to be able to speak. But anyway, they passed it.
April 22nd, the resolution for legal notice in the town.
So it was approved before they disseminated this. And at that point, I would say it was pending. From that point, both the Board of Selectmen and the Board of Education the Board of Finance, they'd all pass this. The next step is a town meeting, which is merely a pro forma. The town meeting can't vote it down, can't do anything. It is then that town meeting at that point, it goes to referendum automatically. The numbers in the flyer were the official numbers that the Board of Finance had approved. They were specific to the referendum that occurred on May the 7th, and that this is technically, I think it was technically pending. You could say that because it hadn't been advertised yet, or you could create some stipulations. But I think the idea here is to prevent the expenditure of public funds to present or to provide propaganda in favor of a budget, or to even provide information regarding the budget, unless, as I read it, and correct me if I'm wrong, Mr. Smith, that the town attorney has reviewed it and approved it, and that the legislative body has approved it. So it requires all three things. It can't advocate, and I didn't say that it did advocate, by the way. That's not anything about that. That's not my allegation. My allegation is it wasn't reviewed by the town attorney, it was not approved by the legislative body, that those three things are required. And as a result, the people who approved it or authorized this expenditure should be required to refund the town the money, as well as attorney fees, which I think they spent a considerable amount trying to defend this action.
The remedy that Mr. Carr just articulated is not one that would be within the jurisdiction of this agency, is that correct?
Not,
We couldn't order people to refund the general fund of the community.
actually, we could if this statute applied. My findings of conclusion doesn't mention advocacy. It articulates the allegations that Mr. Carr had in his complaint, which are the public schools failed to obtain approval by the legislative body and the municipal attorney.
Right.
That is a requirement of 9-369B. But before we apply the statute, we have to see that the referendum was legally pending at the time. Because the language of the statute says it can't advocate no expenditure of state or municipal funds shall be made to influence any person to vote for approval or disapproval of such question. Well, until it's legally pending, there isn't such question. So the commission has consistently said that the last legal condition necessary to require that the time, place, and date of the referendum is going to occur is the triggering event to apply 9-369B. Additionally, the commission has determined that a referendum question is pending when the necessary legal conditions have been satisfied to require the publication of the warning or notice. The warning or notice in this instance wasn't published until May 8th. So at that time, on May 8th, I would agree that should the town choose to publish anything, it would certainly have to very carefully go through the requirements of 9-369B and comply. But this was a full week earlier, so we can't ask the town to walk through 9-369B when it doesn't apply.
Well, Mr. Carr raises an interesting question, and it's not one that occurred to me, because when I read this findings and conclusions statement, I assumed that the referendum was discretionary until some action was taken at the annual meeting. In other words, I assumed that the annual meeting could have adopted the budget. Now, Mr. Carr has just suggested that under Clinton's charter, that is not the case, that a referendum is required for budget adoption. So that raises for me the interesting question as to whether we haven't mistakenly in the past relied on this very technical point of noticing the referendum. In fact, the referendum process was perhaps kicked off as early as the April 22 legal notice, because under their charter there has to be a referendum. So So maybe this case presents an interesting question in that regard, and one that requires further review, because otherwise, let's leave that analysis for just a moment. Otherwise, it seems to me we're left with a town like Clinton, where they could do exactly what they did. Let's make this an advocacy document, or let's find that in fact they did not follow the statutory mandate about the town attorney's review and the legislative body approving the expenditure. We're failing to reach that analysis because we're saying that the notice wasn't given for the referendum. And yet, so we are permitting a town like Clinton to violate the statute in its other particulars if they do it prior to that warning going out for a referendum that is mandated. And I'm not comfortable with that.
Well, I respectfully suggest that you can't violate a statute that doesn't apply to you. And Clinton is not atypical. There are 169 municipalities. I would assume dozens have adjourned town meetings, where the adjourned town meeting annually or biannually creates a referendum at the close of that adjourned town meeting. It happens all the time. And so in the past, where we have municipalities like Clinton, we have suggested that where an adjourned town meeting literally creates a referendum 3 days later, fine. Then the 369B attaches at the close of that adjourned town meeting. If we were to take the approach that you suggest, we would have no bright line as to when we are going to apply the requirements of 9-369B, which literally address advocacy towards the approval of a referendum. If the referendum doesn't exist, then the prohibitions of 9-369B can't apply.
But this is not, again, this is not, and I wouldn't be concerned about this. This is not a question where a referendum is, in a sense, discretionary. Some action has to be taken at the annual meeting, such as a failure to adopt the budget, or a failure to adopt the budget by a certain margin that provides thereafter for a referendum. In Clinton, that referendum is mandated. It's mandated as part of the process, and my concern is, so now we're going to say to these municipalities, don't bother having your town attorney review this publication. Don't bother having your legislative body provide the funds. And don't worry about advocacy. Because for the town of Clinton, there's only a 3-day window there. They're not going to authorize and review and produce a explanatory document in 3 days. So we're basically saying the town of Clinton is outside the statute, and if there are other towns in the state that follow the same procedure, they're also outside the statute. They don't have to run this risk, because basically they can do whatever they want to do until that period arises between the budget meeting and the referendum. And if that's 3 days, so be it. It's not a happy result.
But the difficulty, I think, Steve, that we have is that the way the current law is being applied. All right, this particular instances that occurred in Clinton, where we have difficulty to adjudicate in that respect, how Mr. Carr is saying, because, you know, based upon what he says, April 22nd or 24th, they passed a resolution to initiate a referendum. All right, so that was about 2 weeks or 3 weeks from the day that they said on May 8th that we're going to do this referendum, and then not May 8th, May 14th, and then 3 days later we're going to have the referendum. So I think what Mr. Carr is saying, yes, some legal a resolution was on the table. They approved that, the Board of Education approved it. Yeah, we're going to go out to referendum for this. All right, but until and in all that process, 3 days before the referendum, then the body does its thing. But the law currently allows us, gives us the impression that those other things that Clinton did doesn't apply to the law, and I'm not sure that we could exercise.
But there is, I respectfully appreciate the commissioner's opinions, both of you, but I don't believe there's any construction or legal construction that the commission is doing to apply this statute. I think the plain language in 9-369BA says, paragraph 5, the permissions to create these types of guides, and it says for questions approved for submission to the electors of a municipality at a referendum. So the statute plainly says that a referendum has to exist. That referendum did not exist until, exactly. It is conceivable something may have occurred for that referendum not to have taken place. And if the statute fixes an obligation or a requirement that is about a legally pending referendum, then we have to wait for that referendum to require the application of 9-369B. I don't find that that's a construction. I find that that's a plain reading of this statute. But again, respectfully, you are the commissioners, and I will take your instructions.
May I add something? The town meeting occurs 1 week before the referendum. There would be no opportunity for the Board of Selectmen to review something before the referendum and for it to then be disseminated. I mean, the practicality, this was pending at the time the Board of Finance approved it. At that point, the only thing that would have delayed or changed the referendum would have been an act of God, or the possibility that somebody found out at the newspaper to, when the ad was supposed to run. But other than that, I mean, this was going to happen on May the 7th unless something really, I mean, nothing legally would have stopped it. It would have been something beyond the scope of the act of the legislative body or within the law. It was pending as of that date. And it went to the printer the day after. They waited until they had the Board of Finance's exact numbers before they took it to the printer. So they took, at that point, they knew it was pending, and that's why they printed it then, instead of a week after the referendum or a month before the referendum, before it had been approved by the Board of Finance. Once they knew those numbers, it was pending, and they published their material.
Well, it sounds like what we should do is continue this and talk about, probably maybe in executive session at a later meeting, we want to change the interpretation. Because we've had one interpretation that Attorney Smith has laid out to us, that we've been using all along, it sounds like. Mr. Carr brings up a good point. Both these commissioners here bring up good points. So would the commissioners be amenable to that, to continuing this and then do a little more research and pick it up at the next meeting, perhaps?
I'm happy to do that, except for I would make it very clear that my position is that I'm not interpreting the statutes right now. What I'm doing is I'm applying the plain language of the statutes. And if we're to go to a situation where we regulate a referendum because ordinances, we're now going to be driven by local ordinances to apply state law, then any of the 169 municipalities and dozens of regional school boards, if in their charter or bylaws they have an annual process for a referendum, then they will be perpetually pending. And the application of this law would be virtually impossible. They'll always be pending. And it's just to say that we knew that 3 special elections were coming, and yet disregard the requirement that the governor needed to give notice of 3 special elections. It's like, no, there is a certainty that this statute creates for its application. But again, I say that respectfully, and I'm happy to table this and come back to you with an analysis and perhaps a backstory as to where the commission has been in the past.
Just just provide the statutory language that you're relying on and some indication of the prior decisions.
I'm happy to do
Now,
that.
obviously, but it's a form of interpretation to say you don't have a referendum until you've warned it. That may be a very appropriate legal conclusion. That's not, the statute doesn't say warning, it says, where's the effect if there's going to be a referendum? We have interpreted that to be, it's not pending until it's warned. Right?
Well, it says approved for submission to the electives. It has to be approved for submission to the electives.
Approved for submission. But at a minimum, this matter should go on our legislative agenda because as hyperbolic as your language was about the world's going to fall apart, there's 169 towns out there, and referendums will be perpetual. I would adopting the same type of language say, we've got too many towns out there that are never going to run afoul of this statute because of the way it's being implemented now, and who can produce advocacy documents with impunity because of the circumstance of how their particular charters. That would be my retort. So I think it bears it.
So I'm happy.
No, we're happy to take a look at it.
We'll have a,
We'll analyze it again. The key thing in this is that there has to be some level of bright line testing to certainly apply to all municipalities. And that's what the commission has done in the past, based on, again, the language of the statute and clearly the notice that has to be provided for referendum to occur. We'll have to look at it again and bring back some more analysis.
For all agreement to continue?
Yes, sir.
Okay, we have a motion to continue item 2014-15, so 2014-05.
So, second.
Discussion? All in favor?
Aye.
Opposed? Abstained? 400, continue.
thank you. The next matter is in the matter of complaint by Eva